Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is episode 81 of Business SOS. Very excited that you're here with us, whether it's morning, afternoon, or evening. Thank you for listening. This will be our last episode for 2024. So certainly want to wish everyone a Merry Christmas, Happy Hanukkah, and a prosperous 2025. And certainly thank you for listening to me now close to a year and a half in this podcast. So I'm very excited about that. And we have a very exciting guest coming up for 2025. And I'm going to start the year with Angela Neve. You've heard her before. She's a family law attorney here in Fort Lauderdale. And we're going to be discussing, I believe in January, the first episode in January, we're going to be talking about the rise on the great divorce. So I'm just going to give you kind of a preview of what's going to come in January. So I'm very excited to have her back on board and into the show. So episode 81 of Business SOS, and in the last few weeks I've been talking about litigation, and as you know, I'm a litigation attorney with my firm, the Florida Small Business Legal Center, and I've been doing this now for 20 years. And I talk about the various mistakes people do in litigation and how to avoid them. And one of the common questions that I get, and this is an actual revisited version of the episode. So the topic is, can I afford a lawsuit? And I want to talk from the plaintiff's perspective, the defense perspectives, but I want to break this down a little bit more and more details for you to understand what really goes on in the next 35 minutes that we're together, about really the cost of litigation and what you can expect if you're in a lawsuit. And obviously it's not a very comprehensive list, but I'll give you a good flavor of what to expect. And that's really my objective today. And I think as a business owner, it is important for you to understand the costs and the risk involved in being involved in litigation. Whether you're on the defense side, you're defending a lawsuit, or you're on the plaintiff side, you're the one suing. And as I mentioned before, lawsuits are time-consuming, costly, and require careful planning. So we're going to talk about that today. A typical lawsuit takes about 12 to 18 months to resolve. Sometimes longer, but that's pretty much the average. So when you're looking at a litigation process, you're looking at about a year process of financial commitment, but also personal commitment as well, that you have to involve in terms of communicating with your attorney, responding to discovery requests, making yourself available for meetings or depositions, making yourself available for when there's a deposition of the other side, so you can listen into the deposition and advise your counsel whether another person is telling the truth, or perhaps some details that your attorney may not know about the case at that point that maybe assist the attorney in giving those facts so the attorney can properly answer those questions to the other side. And so what I want to do is basically break the litigation costs in different phases. So right now I want to talk first about what is called a pre-litigation cost. Pre-litigation cost is exactly what it means. It's before you actually initiate the lawsuit. That includes the consultation with the attorney, the case analysis of the case, the legal research about what type of law are you invoking to be able to file that lawsuit. And the attorney probably knows that, since the attorney most likely has done it before. And basically having a plan of action, how many witnesses you plan to call in, how many documents approximately you're talking about reviewing, and making that determination whether the lawsuit should be the first step of your litigation, of your dispute, or perhaps the demand letter should be the first step. It's very common in a business standpoint that we initially begin the process with a demand letter. Whether it's a demand letter, cease and desist letter, as commonly known, or perhaps a demand for payment for an outstanding balance. Just to give an example, in the case of a construction contract, we're required to give a 60-day notice pursuant to the statute. So there, we try to find out whether that would be the first approach that we should take before filing the lawsuit. Many occasions, my approach has been when I send a demand letter, I like to send them with a draft of the lawsuit already prepared, but it has not been filed. And the reason for that is I want to basically show the other side we really have enough evidence and sufficient facts that we can move forward with this lawsuit if we choose to do so. However, this is an opportunity to perhaps discuss solving the problem before a lawsuit actually is filed. That is my approach. Some people have different approaches, but that's the approach that I take. And most of the time, sometimes it gets resolved at that stage simply because the other side knows, hey, you know what, they're ready to go. Versus a letter is easier to draft without the lawsuit, but I like to do both. In my experience, I've gotten better results of doing so. Now, if the letter is ignored, which happens often, or is rejected, or the demand is rejected, or a response is received saying we're not going to agree to your demands, then you as a business owner have a decision to make. The decision is whether I file the lawsuit or not. It's really that simple. If they're not going to agree to your demands, there's no negotiation that can be resolved at that stage, then it's really that simple of a decision. It's an important one, but it's really as simple as all or nothing. Once you file the lawsuit, there's no turning back. You filed it. That opportunity to try to settle before the lawsuit is already gone. So I'm trying to create off-ramps or create stages that perhaps the dispute can be resolved at an earlier stage versus at a much later stage, which is more costly for you as a business owner. So say the demand letter is not responded to, or it is rejected, and there's no negotiation as to the dispute, and you're really faced with that option. The only option is to file a lawsuit. You decide, I'm going to go forward filing that lawsuit. So you go ahead, and there's a preparation of the lawsuit, which most of the time is prepared beforehand, or at least a good working draft is prepared, and preparation of discovery request as well, that often it is served along with the initial pleadings. Most courts, especially in Florida now, they're requiring us to send a case management order with a kind of a schedule of what the timing of the requirements have to be completed by the court for us to go to trial. So that's already included. So it's a kind of a litigation package that is prepared, and that is sent to the process server, who will then serve the documents to the defendant as well, whether it's an individual or it's a corporation. If it's a corporation, it's served to the officer or registered agent. If it's an individual, it is served his or her residence. So now you're in the lawsuit. And remember, regarding the lawsuit, the facts are provided by you. You as the business owner provide the facts. We know the law. We know the elements. We know the causes of action. And based on the facts you provide to us, then we create the lawsuit. But it's important to provide all the facts that you can provide to us. Not send us 1,000 emails. It's just not feasible to analyze all those. But really tell us what happened. As much detail. And I ask my clients if they can provide a narrative in their own words, whether it's dictated in their phone or they type it in with what happened, what led to the dispute, because that helps me, and basically as I'm developing the lawsuit, look at that information, begin to create the various allegations and the complaint. A lawsuit is an art and a science. There's specific elements that have to be pled. There's specific format for us to create the allegations in reference to the paragraph format. So every single line of that in that complaint is important to make sure that it survives what I call, a motion to dismiss. Now, what I call is basically survive a motion to dismiss. In that, once you file the initial lawsuit that has been served, then you go into motion practice. That's in a significant cost involved with that. Motion practice is what it means. You file motions for example, to dismiss, motions to strike the pleadings, there are motions to compel discovery. There's a myriad of motions, and I can have a whole podcast on motions. But for the most part, that's really inside baseball to the degree that lawyers understand. From your perspective, know that there are going to be petitions made to the court by your attorney or from the other side asking the court to do something. The most common one is the motion to dismiss once an initial filing is filed and served, and it's a defensive motion designed to attack the pleadings, attack the complaint, the sufficiency of the complaint. In this particular motion, without getting too technical, what it means is telling the court the complaint is defective on its face. And the court cannot go outside of what I call the four corners of the complaint to make that analysis, to make that decision. And all the allegations are deemed as true against the person or against the party who is filing that motion. Two things can happen. A motion to dismiss is granted or denied. Before that, you got to set that motion to dismiss. You got to set up for hearing. And I'm going to talk about hearings in a few minutes. And then that motion then gets heard by the judge. Sometimes could be on a 5-minute hearing, what we call the uniform motion calendar, or it can be done on a special set hearing. You set a 15-minute, 30-minute time period. For the most part, motion to dismiss are 5 or 15 minutes, not 30 minutes. And then you also, as the person who's receiving that motion, your attorney files what is called a memorandum in opposition to the motion to dismiss. You get the idea. We started just the lawsuit. You're already fighting whether the lawsuit is going to continue, whether it's going to go to first base. So that gives you an indication of a lot of the work that is done. We're not even talking about trial yet. We're not even that close yet. You're just getting started. If a motion to dismiss is granted, for the most part, it's granted without prejudice, with leave to amend. What that means? That means is that the court says, grant the motion, you have 20 days to amend and file another complaint fixing those mistakes. And then the lawsuit continues. If it's denied, then the other party has a number of days to answer the complaint, provided it's called what is answers and affirmative defenses. And the answers the allegations is either admit, deny without knowledge, and they'll raise some of what is called affirmative defenses, which will avoid the claim. And I'm not going to go into details about affirmative defenses. That's another episode that we can talk about. So I have a lot of material to cover as to cost. But I want to kind of give you kind of an idea of how the lawsuit travels through the system, and then we can talk about cost as well. Within this particular time, you already have paid your attorney a significant retainer for the preparation of the lawsuit, the filing service process, and for the most part, to get through that initial challenge to the lawsuit, which is the initial motion to dismiss, which for the most part, attorneys have to expect that if they have done enough of these lawsuits. So we talked about, I mentioned some number of hearings, and I'm just going to run down through some of the hearings that you might hear from your attorney. We have a uniform motion calendar hearing, and I'm focusing most in Florida because that's where I practice. Motion calendar hearings are basically a lot of courts here, like 8:45 in the morning to 9:30. The judge reserves a certain amount of space during time in his or her calendar, and then there's supposed to be matters that you resolve within 5 minutes. Sometimes say longer. But for these hearings, it's not scheduled like you're going to go at 8:45, you're going to go at 8:50. No, you're going to be there from 8:30. You're going to log in a few minutes before if it's on via Zoom. At least at 8:40, you should be ready, waiting for your turn. And then the attorney has to wait sometimes, and sometimes the judges run late. So the attorney can be there from 8:30 to 9:30, sometimes even 10, waiting for his or her turn to be called in for a 5-minute hearing. The attorneys are required before that goes to the judge to meet and confer, and I'm a firm believer on that because a lot of times by the attorneys speaking and talking to each other, the matter can be resolved through whether on the agreed order or the and then avoid the necessity to attend a hearing, have the court make a decision on a hearing, and you don't have to wait. The attorney has to wait for an hour for a 5-minute hearing, which inevitably you will be billed because the attorney's time is dedicating to you, regardless of whether the hearing takes 5 minutes or 10 minutes. There are special set hearings, and that's exactly what it means. The hearings that they're specially set specific time, date, and place. So it could be for a discovery dispute, even a motion to dismiss, depending how long it is, how much material the judge has to go over. But it's set for a specific, could be at 9:30 in the morning, could be at 1 o'clock. That is scheduled with the judicial assistant and or the online system, but it's dedicated to you, and that's actually better because you don't have to wait. You have your time period. Sometimes you got to wait for another hearing to finish, but it's a more efficient way of doing it. Evidentiary hearings that are hearings that they take longer because you're actually providing testimony to the court, live testimony to the court on a particular issue. And then you have calendar call. Calendar call is when the judge calls and there's one more that I forgot to mention. Well, I'll mention now. CMS. It went before about 60 days before the hearing, or actually before the trial, actually maybe 30 days for trial. The judge basically calls a calendar call, which means is that they look at whether or not, A, you're ready for trial, and you should be ready. If you're not ready for trial, why? And the court decides whether or not they will schedule the trial date during that trial period. Sometimes it's a 3-week trial period, sometimes 6-week trial period for your case to be tried. And then you have case management conferences, which the judge, now they're doing it more in Florida, that every month all the attorneys have to show up at court, most likely via Zoom, to let the court know how the case is going. Are you advancing the case? Is there any motions pending? So I mentioned this to you because those are things that you as the business owner not going to be aware of. Those are things that happen behind the scenes. You should be aware of the notices, but for the most part, you do not have to attend these hearings because the court, the judge, the attorney will be handling it unless the attorney tells you got to attend the hearing. You're entitled to attend all the hearings via Zoom. It is your case. So you get notices, you log in, but for the most part, you're not going to speak. Now we get into the discovery phase. So your lawsuit has been filed, survived the motion to dismiss, they filed the answer and affirmative defenses. We usually file a reply to affirmative defenses, but now you have what is called discovery. The discovery phase is one of the most time-consuming and expensive part of the litigation. And I'll tell you why. You have interrogatories that you have to answer under oath, and the other side will have to answer under oath as well. For a case, you have up to 30 interrogatories. You can ask for an additional exemption to have additional interrogatories, but usually they're limited. You have requests for production of documents as well, that you basically be asking for the other side, contracts, emails, text messages, preparing the request for production of documents is very time consuming for both sides. But when I say time consuming, in the back of your mind, I want you to think this is attorney's time, this is paralegal's time that you have to pay for. There's also requests for admissions. These are more simpler because either you admit or deny the allegation, you have to look for any information, and it's basically you respond to those. The deposition of parties and witnesses, and expert witnesses as well. Your deposition will have to be taken as somebody who is a party to the lawsuit, and the other side will have to be taken as well. There's also deposition of witnesses, and I want to make a point here. When I talk to clients and say, I say, how many witnesses do you have? And they say, well, we have 10 witnesses we can call. Everybody will testify for me. And I said, okay, let's talk about that. Because every single witness that you call to testify in, you got to take a deposition. Deposition, you got to pay a court reporter, say $150 an hour for being there at the depot, taking the transcript. But also then you want to order the transcript, which an average for a 2-hour depot, you're going to be paying $650 or more. So the way I look at it, every witness, depending how long the deposition takes, will cost you $1,000 just in cost. If you order the transcripts, and you also, you obviously got to pay their appearance fee. So when analyzing how many witnesses do you have, a better question would be, who are the most important witnesses that will help you prove your case, and prioritize those witnesses, because it's just not financially feasible in many cases to start deposing 10 or 15 witnesses for a case. There are exceptions to every rule, of course, but for the most part, you want to narrow your witnesses to what the ones that are the most important, as opposed to going through this entire list of witnesses that, if the case may get settled, and most cases do, then you really wasted all that money. So you got to prioritize the resources that you have versus what really is necessary for the litigation, because litigation management is key to be able to maintain and control the budget. So let's talk about request for production of documents for a second. You receive 30 different requests for different documents. Many of the requests are repetitive. So your attorney is going to say, okay, send me the documents you have, label the document that you're providing to me to the corresponding number. It'll be helpful to the attorney, helpful to you, because it'll be less time the attorney will have to spend. That if, for example, if they're asking, say it's a real estate dispute, and they ask you for a copy of the real estate contract that you signed. That's request number 1. You send a document to your attorney. This is for request number 1. Email communication about the transaction, about when the offer was made. I'm making that example as I'm talking to you. So if you have an email communication about that occur regarding that particular topic, you send that, but you label it request number 2. In many occasions, when we ask for documents, our clients, not knowing, of course, send us everything at once. And, whether it's paper or whether it's electronic, but the analogy I can give you, if you're given a bunch of pieces of paper together here, figure it out, it's just going to be very time consuming. The same thing with electronic documents. You start sending emails to the attorney. The attorney doesn't have the context of what those communication was, because the attorney was not involved in that communication. So it is more helpful if you label those as well. And this depositions. The deposition is not, once you take the deposition, this preparation for the deposition. A depo prep could take an entire day for the attorney, because he's looking at all the documents, looking at all the discovery, preparing those questions, trying to make sure that those questions that are asked are going to bring the evidence that is necessary for your case, whether you're defending the case or you're the plaintiff of the case, you're suing. There's also communication. Throughout that time, there's constant and very regular communication with opposing counsel's office. Every time a hearing has to be set, we have to communicate. Usually paralegals handle this, which saves you a great deal of money. Coordinating hearings, coordinating appointments, coordinating depositions, setting appointments with you as a client. All that is usually handled by paralegals or office staff. A very important job, but you don't want the attorney doing that simply because it'll cost you more money, and it's just not an efficient way of using the attorney's time, in my opinion. Just to give you an idea of the type of communication that is run through emails, that in most cases you will be billed for this, depending who attorney that you use. You have email communication, email correspondence between you and our office. That's exactly what it means. Email correspondence between, in our case, our office and opposing counsel's office. We got to coordinate hearings, again, depositions, witnesses, hearings, coordination, all that. appointments between the attorneys. Sometimes I make an appointment with this attorney so I can speak with him or her. Email correspondence within the office and the court. We coordinate with the judicial assistants. You get the idea that all that is behind the scenes. And then when you look at your bill, say, wow, I don't know that we're communicating that much. Yes, it's just constant communication between the office. Email correspondence between the office staff as well. We have to delegate the work, so we have to provide them instructions on how to do the work, what to do. There's also service of court documents. Every document that we file with the court is done electronically. It's a process of getting this document uploaded to the court and getting in the proper format so it is accepted by the court. It is also communication with outside vendors, such as court reporters, obviously the court reporter, process servers. If you hire a company to provide some visual aids or preparation of exhibits, that's also a cost. We'll have to communicate with them as well. Then you go into mediation. And mediation, I've done a couple of episodes of mediation, so I'm not going to go in great detail on this. But as you know, it's a process confidential process that you get a mediator to try to resolve the dispute. Mediation can be done at the beginning of the case, can be done closer towards the end of the case. I like to do them at the beginning if possible, if it's feasible, to give the parties an opportunity to resolve the matter without going through the expense of long protracted litigation. But you have to communicate with the opposing counsel as to the selection of the mediator. There's a mediator's deposit that has to be paid. There's a contract with the mediator that has to be signed. There's also preparation for the mediation as well. So if you hear throughout this podcast, you hear the word preparation. Preparation is time. And I remember a mediation that I went to many years ago. The mediator was telling the client, the people that win the case, they do not necessarily have to be the smartest lawyer, okay? But it's a lawyer that prepares the most. And preparation costs money. So that preparation is essential for your case. And there's also the mediation conference as well. Okay, it could take 4 hours, 2 hours. I just had one that took 8 hours. And that takes a tremendous amount of time and expense as well. Then it goes into, say your case has not settled yet, whether by attorney negotiation or has not settled yet by mediation, and you are going to trial. Most cases, most business litigation cases, they settle. They settle for a number of reasons, usually because of cost and the risk. Because when you go to trial, whether it's a judge trial or a jury trial, there will be a winner, there will be a loser. You have no control of the outcome. The judge and the jury will have to control the outcome. When you go to mediation, you control the outcome. You make a decision whether or not this will be settled on your terms. That's why I'm a proponent of mediation. But say it did not get settled. You're going to trial. You want your day in court, and you're entitled to your day in court. So the trial preparation is extensive. Your entire focus, the attorney's entire focus becomes preparing for trial. And there's a number of documents that we got to file with the court to do that. That includes, and again, it's not an exhaustive list, but just to give you an example, there's a list of witnesses and exhibits we got to provide to the court. There are no surprises in business litigation. In most litigation, I'm talking for the context that we practice, there are no surprises here with respect to exhibits. It's not like TV, you put something that the other side has not seen and say, I have this surprise for you, this document, this email. No. We have to provide exhibits in advance to opposing counsel. We have to label them. We have to provide a list of those exhibits to the court, the list of witnesses that we anticipate calling into trial. Then, if you're going to call them into trial, then you have to subpoena those witnesses to show up at trial. So that's additional cost that will incur. And I have not talked about numbers yet. There's a joint pretrial stipulation that we got to prepare, which opposing counsel and I in this case will go through a list of questions that are asked about the parties, the disputes, what is the stipulated fact that is not in dispute, what are facts that are in dispute, what are the counts, all that, and then we sign it, we send it to the court so the judge knows what the case is all about. The objective is to narrow the issue. There are motions for summary judgment as well, and that's a whole different topic altogether. What I want to say, a motion for summary judgment, most likely they have been filed before trial. Those motions are designed to finish the case. And the attorney tells you they just filed a motion for summary judgment against you. It's basically extremely important because the defense of that will hinge whether or not this case gets completed at that point or continues. Or if your attorney says, I'm filing a motion for summary judgment, it means exactly that. I want the judge to make a ruling because there's no need to go to trial. And I'm not going to go into too much detail on that, but I just want to give you an idea. That's a very important motion. It's what is called a dispositive motion. There's a preparation for trial. You have reviewed the case file. We have to review everything again. The preparation of evidence, the presentation, prepare the direct and cross-examination for each witness. You prepare your defense case, prepare your plaintiff's case, and an average takes about 2 days of preparation for every day of trial. So just keep that in mind. And there's staffing. The attorney says, for this particular case, I need another attorney, I need another paralegal. That's something that you'll have to pay for. In terms of cost, just to give you an idea, co-reporters, an average $150 per appearance fee. The process server is about $75 per service, depending on whether it's within state. Transcripts for a 2-hour depo is about $650. These are estimates. The mediators usually go $500 to $700 per hour, depending who they are in their expertise. You have copies, you have exhibits, you have audiovisual rentals, if the court does not provide them. Expert witnesses, and if you bring expert witnesses, they have to be paid as well. They can run between $400 to $600 an hour plus. So a formula that I created, and I get a simple formula, is basically for attorneys, the estimated number of hours per month times the number of months times the number of hours. So again, it's basically how many hours per month. So it could be, you're going to give you, say, 10 hours per month. I'm going to give you an example. Say times 12 months, that's $120 per hour, 120 hours on a 12-month period. I'm using this as an example depending on the activity in the case, and then you multiply that by the hourly rate. So, and I have done this typical, and the same thing with the paralegal, and that's before the trial. So it is not uncommon to have, when you look at the number of months, to have cases that can run $100,000. So that's why it's important to try to get these cases resolved, because most business owners, small businesses, do not have a separate budget for litigation if the insurance does not cover it. Now, once you go into trial preparation, your attorney's focus is going to be mostly full-time on your case. So you can anticipate that hourly rate to be significant. It could be an entire week of like 40 hours on 1 week preparing for your case. So, and if you add another attorney, it can escalate. And some attorneys charge per hour in the trial appearance. Some people charge per day. I'm just giving you an average. If you're going to have a trial for an attorney, $3,500 per day per attorney, 5 days trial, it could cost you about $17,000 per attorney for the entire week. Just give you an example. These are examples that don't apply to any situation. I just want to make you aware of that. This does not include an appeal. The point is this, that the question, can you afford a lawsuit? The answer is maybe. Maybe yes, maybe not. But I want to share these with you with this level of detail to really give you an idea of how to plan for litigation. It is a very important decision to make, but it should not be taken lightly, simply because of the cost that automatically incurs just simply by being part of the process, and the opposing side creates that work for you. So, I use this litigation worksheet as a guide, kind of an estimate, the worst case scenario, to really give my clients a kind of a reality check, because they do not know, listen, this is what you're looking at. How bad do you want this? Or can we solve this? Because we go forward, this is what you're going to be incurring. So that way you know what is anticipated, what is expected if this goes forward all the way through the end of trial. So I hope this information was helpful to you. Again, if you want to reach me, my email is rich@richsierra.com. My website is floridasmallbusinesslegalcenter.com if you're interested in our legal services. We're on Facebook at FSB Legal. We're on Instagram at FSB Legal as well. If you want to watch the video of this podcast, we're youtube.com/@RichardSierra. Our phone number is 866-842-5202. Remember that Business SOS, a common legal mistakes, business owners may and avoid them. It's available on Amazon, Barnes & Noble. You can ask for it in your local bookstore as well. I would like to ask you something. Ask you a favor. If you're listening to a podcast, you like it, I'm going to ask you to please give us a review. Give us a 5-star review, write some comments, share it with your friends. That helps the algorithm of Apple Podcasts or Spotify to really share with other business owners. But I'm going to ask you to please, if you can do that for me, I certainly would appreciate it. Until next year, this is Rich Sierra. I would like to wish you, before I finish here, a very Merry Christmas, Happy Hanukkah, Happy Holidays, and a prosperous 2025. Happy New Year. And I want to thank you again for listening to me for this last year and a half. And I look forward to an exciting year in 2025. And remember that my goal is to help you succeed.